Ladies and gentlemen, good afternoon. This is the people of the state of California against Jared Daniel Elkins. The record will reflect that Ms. Fox is present on behalf of the district attorney representing the people. Mr. Johnston and Ms. Webb are present on behalf of Mr. Elkins. Mr. Elkins is personally present in the courtroom as well. We have been informed, ladies and gentlemen, that the jurors have reached verdicts in this case. In a few moments, I will have them enter the courtroom. If all is in order with their verdict forms, then I will receive the verdicts, whatever they may be. I am mindful that this has been a difficult and highly emotional case on both sides of the courtroom. One of the things that the law tries to do is to address matters such as this in a way that does not allow those emotions to improperly affect the verdicts and the decision. I want all spectators to know that, of course, you are welcome to be present in this courtroom. However, I expect all spectators to respect the law, to respect the judicial process, and to control your expressions of emotions when the verdicts are read, whatever they may happen to be. Addressing the bailiffs, may we have the jurors, please?
Remain seated and come to order. Department 2003 is now in session.
Ladies and gentlemen, good afternoon. The record will reflect that the jurors have entered the courtroom. Ladies and gentlemen, I thank you for the conscientious service that you've given us in this case. I am given to understand that the jury has reached verdicts. Is this correct? I see affirmative responses from all. Who is the foreperson, please? And this is Mr. Juror number 10. Mr. Juror number 10, have you completed the verdict forms? Have you dated them and signed them with Juror 10 as foreperson? Do you believe that the verdict forms, as you have completed them, accurately and correctly reflect the jurors' findings in this case? May I ask that you hand those to the bailiff, please? Thank you. I have reviewed the verdict forms. Each appears to be regular and complete on its face. I see no internal inconsistencies among the verdict forms. Each is dated and signed. Today's date and juror number 10 is foreperson speaking on behalf of the jurors. Counsel and parties, feel free to remain seated while I read the verdicts. In the Superior Court of the State of California, in and for the County of San Diego, the people of the State of California, plaintiff versus Jared Daniel Elkins, defendant. Case SCD 274583. Verdict as to count 1. We, the jury, in the above entitled cause, find the defendant, Jared Daniel Elkins, guilty of the crime of forcible rape in violation of Penal Code Section 261, Subdivision A2, as charged in Count 1 of the amended information, dated December 19th, 2018, signed Juror number 10 as foreperson. Addressing the verdict for Count 2, same court, same cause. We, the jury, in the above entitled cause, find the defendant, Jared Daniel Elkins, not guilty of the crime of rape of an intoxicated person in violation of Penal Code Section 261, Subdivision A3, as charged in Count 2 of the amended information, dated December 19th, 2018, signed Juror number 10 as foreperson. Same court, same cause, verdict as to Count 3. We, the jury, in the above entitled cause, find the defendant, Jared Daniel Elkins, guilty of the crime of oral copulation by force in violation of Penal Code Section 288A, Subdivision C2A, as charged in Count 3 of the amended information, dated December 19th, 2018, signed Juror number 10 as foreperson. Same court, same cause, verdict as to Count 4. We, the jury, in the above entitled cause, find the defendant, Jared Daniel Elkins, not guilty of the crime of oral copulation of an intoxicated person in violation of Penal Code Section 288A, Subdivision I, as charged in Count 4 of the amended information, dated December 19th, 2018, signed Juror number 10 as foreperson. Same court, same cause, addressing the verdict as to Count 5. We, the jury, in the above entitled cause, find the defendant, Jared Daniel Elkins, not guilty of the crime of oral copulation of intoxicated person, a separate act, in violation of Penal Code Section 288A, Subdivision I, as charged in Count 5 of the amended information, dated December 19th, 2018, signed Juror Number 10 as foreperson. Same court, same cause, verdict as to Count 6. We, the jury, in the above entitled cause, find the defendant, Jared Daniel Elkins, guilty of the crime of oral copulation by force in violation of Penal Code Section 288A, Subdivision C2A, as charged in Count 6 of the amended information, dated December 19th, 2018, signed Juror Number 10 as foreperson. Same court, same cause, verdict for Count 7. We, the jury, in the above entitled cause, find the defendant, Jared Daniel Elkins, guilty of the crime of sexual penetration by force in violation of Penal Code Section 289, Subdivision A, as charged in Count 7 of the amended information, dated December 19th, 2018, signed Juror Number 10 as foreperson. Same court, same cause, addressing the verdict as to Count 8. We, the jury, in the above entitled cause, find the defendant, Jared Daniel Elkins, not guilty of the crime of sexual penetration of an intoxicated person in violation of Penal Code Section 289, Subdivision E, as charged in Count 8 of the amended information, dated December 19th, 2018, signed Juror Number 10 as foreperson. Addressing the jurors as a group, ladies and gentlemen of the jury, are these and were these your verdicts as I have read them? I believe I see all affirmative responses, and thank you. Addressing counsel, does either counsel wish the jurors polled?
Yes, Your Honor.
Ladies and gentlemen, when we refer to polling the jurors, it means I'm going to ask each one of you individually if these are your correct verdicts as I have read them. I will begin with Juror Number 1. Juror Number 1, are these your verdicts as I read them? Juror Number 2, are these your verdicts as I read them? Juror Number 3, are these your verdicts as I read them? Juror Number 4, are these your verdicts as I read them? Juror Number 5, are these your verdicts as I read them? Juror Number 6, are these your verdicts as I read them? Juror Number 7, are these your verdicts as I read them? Juror Number 8, are these your verdicts as I read them? Juror Number 9, are these your verdicts as I read them? Juror Number 10, are these your verdicts as I read them? Juror Number 11, are these your verdicts as I read them? Juror Number 12, are these your verdicts as I read them? Thank you. I have 12 individual jurors affirming that these are their verdicts. I therefore direct the clerk to enroll the verdicts as recorded and read. This occurring, inquiring of both counsel, do counsel waive further reading of the verdicts as now recorded?
Yes, Your Honor.
All right, thank you. Ladies and gentlemen, where do we go from here? First of all, I want to thank you on behalf of the court, as well as both sides to this difficult case, for your conscientious attention and the service that you have given us. I'm aware that it's been some time since we first met. When we did first meet, I mentioned to you that the reason that you are here is to carry out the command of the Sixth Amendment to the United States Constitution. That amendment provides that each person in this great nation of ours who is charged with a crime which, if incarceration could result, if a guilty verdict is found, is entitled to have that ultimate question, is there enough evidence for a guilty verdict to be decided by jurors rather than by the court? As we discussed at length during the jury selection process, I think this is a marvelous strength of our constitutional system, but it requires people such as yourselves to donate your time and your attention and your efforts and your strength and moral courage to roll up your sleeves and listen to highly contentious and difficult evidence and render verdicts according to the law. I have every confidence that you have done that, and I thank you wholeheartedly on behalf of the courts and on behalf of both sides for doing this. Procedurally, where we go from here is this. Not surprisingly, your jury service is finished, ladies and gentlemen, this time around. You will be free to leave in just a few minutes. The admonition that I have been giving you and reminding you each time that we broke about not discussing the case with any other person or forming or expressing any opinion on it is now off. You are free to discuss the case with anybody you would like. You are also free not to discuss the case with anybody. If you believe that anyone is asking for information or wishing to discuss the case and you don't wish to respond, then please just firmly say, I prefer not to answer. If that person, whoever it might be, would persist, please let me know, because that's a violation of the court rules, and it will be addressed. I also must remind you, as we discussed, I think, during the jury selection process, that you may not, under the law, agree to accept any form of consideration or payment for what it was like to be a juror on this case until at least 90 days have elapsed from this day. This was a difficult case, ladies and gentlemen. I have every confidence, conscientiously approached it. Your oath of jurors required that you decide this case based solely on the law and the evidence and render a true verdict based on those two things, and I have every confidence that you did this. We cannot make this system work without you, and I appreciate very much the efforts that you have given us. I'm going to excuse you at this time. I will invite you to follow the directions of the bailiff and exit through the back door here. And I would consider it a privilege to work with any one of you the next time that the computer seizes upon your name and invites you down for jury service. Thank you, ladies and gentlemen. You are excused. In just a moment, I'm going to excuse the spectators, but I have a couple of directions before we do that. First of all, it is my intention to remand Mr. Elkins to custody. Mr. Johnston, do you wish to be heard with respect to that intention?
I do, Your Honor.
You may.
This case arose out of events that occurred over a year ago in September of last year. Mr. Elkins has been out on bond that entire time. I think the court has been aware that he's been appeared at every court appearance he's been asked to appear at. He's behaved himself through the trial that I think the court has acknowledged is very difficult from both sides. He knew there was a verdict today. He appeared. With his law enforcement background, I think Mr. Elkins could be expected to continue to appear and to abide by the conditions of bond. Certainly the court has in mind the March incident, the 1108, but he's known about that for over half a year as well, and has continued to abide by the conditions of release. And I think the court had every confidence that he would remain and come back to court to face the punishment the court imposes. Mr. Elkins has also remained in the state of California during the time the court's order.
Mr. Johnson, I respect your viewpoints, but in a case of this seriousness, it is my practice to remand defendants to custody after verdicts such as these, and I don't see a reason not to follow that in this case. I am therefore going to order that Mr. Elkins be remanded to the custody of the sheriff without bail pending a sentencing hearing. Mr. Elkins, if you will please follow the directions of the bailiff. Thank you, and you may be seated. Addressing counsel, the demand time date for a sentencing hearing would be within 20 court days. Mr. Johnson, I'm willing to entertain an enlargement of that time. I would propose that if you intend to bring post-trial motions, that we set those on the same date that I would set for the sentencing hearing. Depending on the outcome of those motions, the sentencing hearing either would or would not proceed. Would you prefer a demand time date, or would you prefer an enlargement of time?
An enlargement, Your Honor.
All right. What time period would you ask?
I'm going to try to think of a reasonable date here today. I had mentioned to Ms. Fox sometime late in February, but if we're going to do post-trial motions as well, if I could ask for a date, perhaps in early March, that would give me an opportunity to review the record of the case and prepare those motions.
Ms. Fox, do you have an objection if we set this the first week in March? All right. Inquiring of the clerk, are March 1st and March 8th available to the court? Is March 8th available? All right. Mr. Johnson, Mr. Elkins has a right to have that sentencing hearing within 20 days. That is a statutory right. You are authorized to waive that on his behalf. Does he waive that right?
Yes, Your
All right, thank you. I accept that waiver. This matter will be set for sentencing hearing, probation hearing and sentencing hearing, and hearing on any post-trial motions that will be filed. That date will be March 8th, 2019 at 9 o'clock in this department. Mr. Elkins is to be held without bail in the interim. His bond will be exonerated. He is ordered produced at that time and place. Inquiring of counsel for the people, is there anything further from the people at this stage of this proceeding? All right. Inquiring of counsel for the defense. Mr. Johnson, is there anything further on behalf of the defense for this proceeding?
Not this time around.
All right, thank you. Ladies and gentlemen, I am mindful of what a difficult case this has been for people on both sides of the courtroom. And I can see and have seen throughout the trial the anguish on both sides of this courtroom. I ask, in fact I direct, that all spectators please observe appropriate decorum when you are leaving. I am also mindful that members of the news media may wish to speak with any of you who would wish to speak with the news media. To try to assure that this would occur in an orderly manner and to prevent possible breaches of the peace, I'm going to invite the people on your left side of the courtroom, namely the victims' families and supporters, and any news media and personnel who are there, to leave the courtroom first, and I would invite you to go to the right-hand side as you exit the courtroom and wait out there. If you wish to talk to the news media, please, that can occur at that time. In any event, please wait out there until the people on the left side of the courtroom, Mr. Elkins' family and supporters, have had a chance to leave. You folks are welcome to remain to talk to news media if you wish, but if you wish, you can go out the courtroom and go to the left and go down to the elevators, and you will be able to exit unmolested. With that, I'm going to invite the people on the right side of the courtroom, your right side of the courtroom, to leave. When you leave, please go to the right. Spectators have left the courtroom. Unless either counsel has anything further, this proceeding is concluded. Ms. Fox? Mr. Johnston? Anything further?
No, Your Honor.
Mr. Elkins, please follow the directions of the bailiff. Thank you. We are adjourned.